Hello and welcome to today's episode, which deals with arbitration and settlement of disputes. Students, let's start with the basic terms and then the concepts. Arbitration, a form of alternative dispute resolution, is a technique for the resolution of disputes outside the courts. The parties to a dispute refer to arbitration by one or more persons, the arbitrators, arbiters, or arbitral tribunal, and agree to be bound by the arbitration decision. A third party reviews the evidence in the case and imposes a decision that is legally binding on both sides and enforceable in the courts. Alternative dispute resolution, known in some countries such as Australia as external dispute resolution, includes dispute resolution process and techniques that act as a means for disagreeing parties to come to an agreement short of litigation. It is collective term for the ways that parties can settle disputes with or without the help of a third party. Arbitrator, an independent person or body officially appointed to settle a dispute. Arbiter, a person who settles a dispute or has ultimate authority in a matter. A person whose views or actions have influence in a particular sphere. An arbitral tribunal is a panel of one or more adjudicators which is convened and sits to resolve a dispute by way of arbitration. The tribunal may consist of a sole arbitrator, or there may be two or more arbitrators, which might include a chairman. Before we go any further, allow me to give you a quick introduction about myself. I am Ms. Pallavi Mohan, working since 17 plus years, both nationally and internationally. Recent assignment was with Samsung Electronics as corporate communication professional. Students, let's understand with an example. Example, year 2016. Month of May, Arbitration Tribunal asks Steel Authority of India (SAIL) to pay 323 crore rupees to SR Shipping. Mumbai, an Arbitration Tribunal has directed the Steel Authority of India to pay about 323 crores to SR Shipping for illegally terminating a contract and causing damages and losses to the Ruya controlled company. The panel headed by former Supreme Court Justice Deepak Kumar Verma passed the award in favor of SR Shipping and directed state-owned Steel Authority of India to pay the money. Example make things easy to understand. I am sure you are aware of the steel industry and what happened to it early this year. One should thus understand how to cope up with problems and solve them with higher knowledge and legal practices. Students, now we will start with understanding some important criteria for arbitration and settlement of disputes. Arbitration is often used for the resolution of commercial disputes, particularly in the context of international commercial transactions. In certain countries, such as the United States, arbitration is also frequently employed in consumer and employment matters, where arbitration may be mandated by the terms of employment or commercial contracts. Arbitration can be either voluntary or mandatory, although mandatory arbitration can only come from a law or from a contract that is voluntarily entered into, where the parties agree to hold all existing or future disputes to arbitration without necessarily knowing specifically what disputes will ever occur, and can be either binding or non-binding. Non-binding arbitration is similar to mediation in that a decision cannot be imposed on the parties. However, the principal distinction is that whereas a mediator will try to help the parties find a middle ground on which to comprise, the non-binding arbitrator remains totally removed from the settlement process and will only give a determination of liability and, if appropriate, an indication of the quantum of damages payable. By one definition, arbitration is binding and non-binding arbitration is therefore technically not arbitration. Arbitration is a proceeding in which a dispute is resolved by an impartial adjudicator whose decision the parties to the dispute have agreed or legislation has commanded will be final and binding. There are limited rights of review and appeal of arbitration awards. Arbitration is not the same as 1. Judicial proceedings, although in some jurisdictions court proceedings are sometimes referred as arbitrations. 2. Alternative dispute resolution. 3. Expert determination. 4. Mediation, a form of settlement negotiation facilitated by a neutral third party. Students, it is very important to pay attention to these concepts. Let's now comprehend the advantages and disadvantages. Parties often seek to resolve disputes through arbitration because of a number of perceived potential advantages over judicial proceedings. First, in contrast to litigation where one cannot choose the judge, arbitration allows the parties to choose their own tribunal. This is especially useful when the subject matter of the dispute is highly technical. Arbitrators with an appropriate degree of an expertise, for example, quantity surveying expertise in the case of a construction dispute or expertise in commercial property law in the case of real estate dispute, can be chosen. Second, arbitration is often faster than litigation in court. Third, arbitral proceedings and an arbitral award are generally non-public and can be made confidential. Fourth, in arbitral proceedings, the language of arbitration may be chosen, whereas judicial proceedings, the official language of the country of the competent court will be automatically applied. Fifth, because of the provisions of the New York Convention 1958, arbitration awards are generally easier to enforce in other nations than court verdicts. Sixth, in most legal systems, there are very limited avenues for appeal of an arbitral award, which is sometimes an advantage because it limits the duration of the dispute and any associated liability. Some of the disadvantages include: first, arbitration agreements are sometimes contained in ancillary agreements or in small prints in other agreements, and consumers and employees often do not know in advance that they have agreed to mandatory binding pre-dispute arbitration by purchasing a product or taking a job. Second, if the arbitration is mandatory and binding, the parties waive their rights to access the courts and to have a judge or jury decide the case. Third, if the arbitrator or arbitration forum depends on the corporation for repeat business, there may be an inherent incentive to rule against the consumer or employee. Fourth, there are very limited avenues for appeal, which means that a flawed decision cannot be easily overturned. Fifth, although usually to be speedier when there are multiple arbitrators on the panel, juggling their schedules for hearing dates in long cases can lead to delays. Sixth, in some legal system, arbitration awards have fewer enforcement options than judgments. Although in the United States, arbitration awards are enforced in the same manner as court judgments and have the same effect. Seventh, arbitrators are generally unable to enforce interlocutory measures against a party, making it easier for a party to take steps to avoid enforcement of member or a small group of members in arbitration due to increasing legal fees, without explaining to the members the adverse consequence of an unfavorable ruling. Eighth, discovery may be more limited in arbitration or entirely non-existent. Ninth, the potential to generate billing by attorneys may be less than pursuing the dispute through trial. 10. Unlike court judgments, arbitration awards themselves are not directly enforceable. A party seeking to enforce an arbitration award must resort to judicial remedies called an action to confirm an award. Arbitrability. By their nature, the subject matter of some dispute is not capable of arbitration. In general, two groups of legal procedures cannot be subjected to arbitration. First, procedures which necessarily lead to a determination which the parties to the dispute may not enter into an agreement upon. Some court procedures lead to judgments which bind all members of the general public or public authorities in their capacity as such, or third parties, or which are being conducted in the public interest. For example, until 1980s, antitrust matters were not arbitrable in the United States. Matters relating to crime, status and family laws are generally not considered to be arbitrable, as the power of the parties to enter into an agreement upon these matters is at least restricted. However, most other disputes that involve private rights between two parties can be resolved using arbitration. In some disputes, parts of claim may be arbitrable and other parts not. For example, in a dispute over patent infringement, a determination of whether a patent has been infringed could be adjudicated upon by an arbitrational tribunal, but the validity of a patent could not. As patents are subjected to a system of public registration, an arbitral panel would have no power to order the relevant body to rectify any patent registration based upon its determination. Second, some legal orders exclude or restrict the possibility of arbitration for reasons of the protection of weaker members of the public. Example, consumers. Example, German law excludes dispute over the rentals of living space for any form of arbitration, while arbitration agreements with consumers are only considered valid if they are signed by either party and if the signed documents do not bear any other content other than arbitration agreement. Arbitration agreement. Arbitration agreements are generally divided into two types. First, agreements which provide that if a dispute should arise, it will be resolved by arbitration. These will generally be normal contracts, but they contain an arbitration clause. Second, agreements which are signed after a dispute has arisen, agreeing that the dispute should be resolved by arbitration. The former is the far more prevalent type of arbitration agreement. Sometimes legal significance attaches to the type of arbitration agreement. For example, in certain Commonwealth countries, not including England and Wales, it is possible to provide that each party should bear their own cost in a conventional arbitration clause, but not in a submission agreement. In keeping with the informality of the arbitration process, the law is generally keen to uphold the validity of arbitration clauses even when they lack the normal formal language associated with legal contracts. Clauses which have been upheld include arbitration in London, English law to apply, suitable arbitration clause, arbitration, if any, by ICC rules in London. The courts have also upheld clauses which specify resolution of disputes other than in accordance with a specific legal system. These include provision indicating that the arbitrators must not necessarily judge according to the strict law, but as a general rule must primarily to consider the principle of practical business. Internationally, accepted principles of law governing contractual relations. Agreements to refer disputes to arbitration generally have a special status in the eyes of the law. For example, in disputes on a contract, a common defense is to plead the contract is void and thus any claim based upon it fails. It follows that if a party successfully claims that a contract is void, then each clause contained within the contract, including the arbitration clause, would be void. However, in most countries, the courts have accepted that a contract can only be declared void by a court or other tribunal, and if the contract, valid or otherwise, contains an arbitrational clause, then the proper forum to determine whether the contract is void or not is the arbitration tribunal. Arguably, either position is potentially unfair. If a person is made to sign a contract under force and the contract contains an arbitration clause highly favorable to the other party, the dispute may still refer to that arbitration tribunal. Conversely, a court may be persuaded that the arbitration agreement itself is void, having been signed under force. However, most courts will be reluctant to interfere with the general rule, which does allow for commercial expediency. Any other solution where one first had to go to court to decide whether one had to go to arbitration would be self-defeating. Arbitral tribunal. The arbitrators which determine the outcome of the dispute are called the arbitral tribunals. The composition of the arbitral tribunals can vary enormously, with either a sole arbitrator sitting, two or more arbitrators, with or without a chairman or mediator, and various other combinations. In most jurisdictions, an arbitrator enjoys immunity from liability for anything done or omitted while acting as arbitrator, unless the arbitrator acts in bad faith. Arbitrations are usually divided into two types: 1. Ad hoc arbitration, and 2. Administered arbitration. In ad hoc arbitrations, the arbitral tribunals are appointed by the parties or by appointing authority chosen by the parties. After the tribunal has been formed, the appointing authority will normally have no other role, and the arbitration will be managed by the tribunal. In administered arbitration, the arbitration will be administered by a professional arbitration institution providing arbitrational services such as the London Court of International Arbitration, LCIA in London, or the International Chamber of Commerce, ICC in Paris, or the American Arbitration Association in the United States. Normally, the arbitration institution also will be appointing authority. Arbitration institutions tend to have their own rules and procedures and may be more formal. They also tend to be more expensive and, for procedural reasons, slower. Duties of the tribunal. The duties of the tribunal will be determined by a combination of the provision of the arbitration agreement and by the procedural law which apply in the seat of arbitration. The extent to which the laws of the seat of arbitration permit party autonomy, the ability of the parties to set out their own procedures and regulations, determines the interplay between the two. However, in almost all countries, the tribunal owes several non-derogable duties. These will normally be: first, to act fairly and impartially between the parties, and to allow each party a reasonable opportunity to put their case and to deal with the case of their opponent. And second, to adopt procedures suited to the circumstances of the particular case, so as to provide a fair means for resolution of the dispute. Arbitral awards. Although arbitration awards are characteristically an award of damages against a party, in many jurisdictions tribunals have a range of remedies that can form a part of the award. These may include: 1. Payment of a sum of money; second, the making of a declaration as to any matter to be determined in the proceedings; 3. In some jurisdiction, the tribunal may have the same power as a court to: first, order a party to do or refrain from doing something; second, to order specific performance of a contract; to order the rectifications, setting aside or cancellation of a deed or other documents. Fourth, in other jurisdictions, however, unless the parties have expressly granted the arbitrators the right to decide such matters, the tribunal's power may be limited to deciding whether a party is entitled to damages. It may not have the legal authority to order injunctive relief, issue a declaration, or rectify a contract, such powers being reserved to the exclusive jurisdiction of the courts. Nomenclature. As methods of dispute resolution, arbitration procedures can be varied to suit the needs of the parties. Certain specific types of arbitration procedures have developed, particularly in the North America. First, judicial arbitration is usually not arbitration at all, but merely a court process which refers to itself as arbitration, such as small claims arbitration before the country courts in the United Kingdom. Online arbitration is a form of arbitration that occurs exclusively online. There is currently an assumption that online arbitration is admissible under the New York Convention and the E-commerce Directive, but this has not been legally verified. Since arbitration is based on a contractual agreement between the parties, an online process without a regulatory framework may generate a significant number of challenges from consumers and other weaker parties if due process cannot be assured. Third, high-low arbitration or bracketed arbitration is an arbitration wherein the parties to the dispute agree in advance the limits within which the arbitral tribunal must render its award. It is only generally useful where liability is not in dispute and the only issue between the party is the amount of compensation. If the award is lower than the agreed minimum, then the defendant only need to pay the lower limit. If the award is higher than the agreed maximum, the claimant will receive the upper limit. If the award falls within the agreed range, then the parties are bound by the actual award amount. Practice varies as to whether the figures may or may not be revealed to the tribunal or whether the tribunal is even advised of the parties' agreement. Fourth, binding arbitration is a form of arbitration where the decision by the arbitrator is legally binding and enforceable, similar to a court order. Fifth, non-binding arbitration is a process which is conducted as if it were a conventional arbitration, except that the award issued by the tribunal is not binding on the parties and they retain their rights to bring a claim before the courts or other arbitration tribunals. The award is in the form of an independent assessment of the merits of the case, designated to facilitate an out-of-court settlement. State law may automatically make a non-binding arbitration binding if, For example, the non-binding arbitration is court-ordered and no party requests a trial de novo. Pendulum arbitration refers to a determination in industrial disputes where an arbitrator has to resolve a claim between a trade union and management by making a determination of which of two sides has the more reasonable position. The arbitrator must choose only between the two options and cannot split the difference or select an alternative position. It was initiated in Chile in 1979. This form of arbitration has been increasingly seen in resolving international tax dispute, especially in the context of deciding on the transfer pricing margins. This form of arbitration is also known as baseball arbitration. It takes its name from a practice which arose in relation to salary arbitration in Major League Baseball. Seventh, night baseball arbitration is a variation of baseball arbitration where the figures are not revealed to the arbitration tribunal. The arbitrator will determine the quantum of the claim in the usual way, and the parties agree to accept and be bound by the figures which is closest to the tribunal's award. Such form of last offer arbitration can also be combined with the mediation to create Medalau hybrid process, mediation followed by last offer arbitration. 4 important questions before we end this episode. First, what does an arbitrator do? The essence of arbitration is that it is an agreement between two or more parties to try to resolve a dispute outside of the court system. The parties agree upon a third party as an arbitrator who will act as a judge and jury. Second, what is the procedure of arbitration? Arbitration is a process in which the parties to a dispute present arguments and evidence to a dispute resolution practitioner who makes a determination. Using this process, the parties to the dispute choose an independent third party known as an arbitrator to act as a judge. Third, is arbitration decision final? In binding arbitration, the arbitrator's decision is final. It may not be reviewed or overturned by a court except in very limited circumstances, such as when fraud or misuse of power has been involved. In non-binding arbitration, either party may reject the arbitration award and demand a trial instead. Fourth, what is the difference between arbitration and interest arbitration? Interest arbitration is a process whereby the issue not resolved in the bargaining between the employer and the union may be presented to an impartial arbitrator for final resolution. Interest arbitration is not permitted under RCW, Revised Code of Washington. Students, we have today understood the topic arbitration and settlement of disputes and covered terms and concepts related to it. That is all for today. Hope you have understood. We'll see you again with the next topic. Till then, take care. Bye.